with consent of the petitioner, I beg to mention item 12, my lord.
Yes.
Some instruction is required. Lordship may fix up to 3 weeks.
You're for,
I'm
Ma-
the department.
My lord, I am for the petitioner, my lord. My lord, my humble prayer is that kindly a date may be fixed after 3 weeks, my lord. That's
it will be very difficult to fix the particular date.
because my lord, it's a long pending matter.
2022,
Yes, my lord.
yes. On the prayer of Mr.
SK Talukdar.
S.K. Talukdar, Learned Council, Standing Council
Standing now.
for
Corporation Department.
Corporation Department. List this, and prayer not being objected to the Learned Council, Mr. D.P. Bora, for the petition. List this matter after 3 weeks.
God bless you.
Lordship, I beg to mention item number 6 of the supplementary list here, Lordship, for
Supplement-
listing after 2 weeks, Your Lordship, as my senior Mr. NNB Chaudhary is unwell today, Your Lordship.
Item 6,
Yes, Your Lordship.
what is this? What do you want?
After 2 weeks, Your Lordship, my senior is unwell today.
On the ground that Mr. NNB Chaudhary,
NNB Chaudhary is unwell. I myself is
Learned
current
Council,
secretary.
for the petitioner is not keeping well. Comma, Mr. So-and-so Learned Council for the president, press for adjournment of the matter for 2 weeks. Yes, allowed. This after 2 weeks.
I'd like to motion item number 16 of the supplement.
I'm appearing for the petitioner, Lordship.
Yes,
The Lordship, I'm seeking for an adjournment of the matter.
why?
The Lordship, the engaged senior counsel has some difficulties with it.
On the ground that Mr. M.U. Mohammed,
No, BD Das Lordship.
you are for
I'm for BD Das Lordship.
petitioner or respondent?
Respondent number.
16.
Yes, Lordship.
On the ground that Mr. Bidiras,
Yes, Lordship.
the senior counsel,
Yes.
has some personal difficulty. Come on, Mr. So-and-so, press for adjournment of the matter. Mr. Prayer not being objected to by the
Please
counsel for the
deboard
petition.
petitioner.
List this matter after 3 weeks.
After 1 week, Lordship.
After 2 weeks.
My pleasure, Lordship. Lordship, I beg to mention item number 4 and 5, my lord. Matter may pass over for the and fixed after.
Why?
Due to some difficulties of engaged counsel, my lord.
What difficulty? What is the matter?
My lord, actually, I am not aware about the matter. My suddenly
Please don't make a mention.
suddenly instructed to make mention, my lord.
Huh?
Suddenly, I have instructed to make mention, my lord, on behalf of engaged counsel, my lord.
Who is the engaged counsel?
My lord,
Who is the engaged counsel?
Ziuddin, my lord. Ziuddin, matter is
There's
challenging the
nothing.
impudent advertisement, my lord.
Anyway,
CGPO.
on the
Matter
prayer of
relating to the
Mr.
appointment of
So-and-so, Learned Counsel appearing on behalf of Mr. Jiuddin. List this matter after 4 weeks.
2 weeks, my lord.
4 weeks.
4 weeks.
Information was not given by you.
Yes, next.
Master Lordship.
Information was not given.
May
Therefore, mentioned, Sir. You are the respondent. No information was given.
What is the matter? Huh?
Anyway, Lordship, I have no objection for.
Okay.
Information was necessary.
Yes, yes.
My lord.
Next time,
Next time,
don't do that.
May I please do-
Yes, yes,
Lordship, I beg to mention item number 18 for passable
18.
for
yes.
For passable, Lordship.
Why?
My senior is not available today.
Hmm?
Lordship. My senior is out of station today. Lordship.
On the prayer of Mr. So-and-so, Learned Counsel for the list this letter after 4 weeks.
May I proceed, Lordship? Lordship, I am appearing on behalf of Mr. P.K. Roy Chaudhary for item number 8 on supplementary list.
Item
Kindly
8.
listed another document after 2 weeks.
Yes. So moved.
Pleasure.
Please, your Lordship. Lordship, I beg to mention item number 14 on with the consent of the other party, Lordship. I beg
1
for-
4. Yes, you are for?
I'm appearing on behalf of Mr. A. Ahmed.
A. Ahmed
Yes.
for petitioner.
Petitioner, yes.
No objection. On the prayer of Mr. M.S. So-and-so, Learned Counsel appearing on behalf of Mr. A. Ahmed and prayer not being objected to by M.S. S. Todi, Learned Counsel for the respondent number 2 to 4. List this matter after 4 weeks.
May I please, Your Lordship?
In this matter, Lordship, our learned senior government advocate will appear, Lordship. He is in court number one, Lordship. He will come, Lordship. Thanks, pass over for this.
No, for the day, Lordship.
No, what is your prayer?
Prayer is, Lordship, that in pursuance of this court of the honorable court, this petitioner is supposed to be reinstated in their post. However, Lordship, in the said order, Lordship, the court has directed to reinstate this petitioner and also impose cost upon the erring Lordship respondent.
Yes.
They have, Lordship, paid that cost, but though order was passed in 19, till then, Lordship, they have not been reinstated. Lordship.
Then you have missed you have already sailed over.
No, thing is that, Lordship.
If they have not complied with the court's order, it's not a second writ petition.
No. Court order was just, Lordship will find the order of this honorable court.
Because there are two court orders,
Lordship
not
will
only
find-
one court order.
No, kindly, Lordship, see the order dated 17/12/2019.
Where it
The
is
operative portion is at page number 77 of my
77.
writ petition, Lordship.
Yes,
The last paragraph I am reading was
yes.
paragraph number 4.
Hmm.
Mr. T. Doloy, Learned Counsel for the Social Welfare Department, has made an oral submission that cancellation of appointment of the petitioners were made by following the direction of the court in its order dated 27/6/13 in WBC number 232413. We have perused the order dated 27/6/13, but we have not noticed any such direction by this court to cancel the appointment of the petitioner, nor any such direction is discernible in the communication of the director made to the CDPO dated so. From such a view of the matter, practically in the context of the oral submission of the Learned Counsel for the Social Health Department, there doesn't appear any apparent justifiable reasons to cancel the appointment of the petitioner. An attempt is also made by the Mr. T. Dory, Learned Counsel, by referring to a document annexed at Annexure V, page 52 of the writ petition, which is claimed to be final report dated 29/1/2011 of the Circle Officer, Tokuakhana Revenue Circle, to take a stand that the cancellation of appointment of the petitioner were also pursuant to the said purported enquiry report dated 29/1/11. We even gone through the enquiry report dated 29/1/2011, but we have noticed that in the enquiry report, nothing.
What's the order dated 27/6/2013?
Yes. That Lordship will find at just starting from page number Lordship 68. Small order, just I'm reading Lordship, page number 68.
Hmm.
Yes. Heard Mr. Vijay Soikal, Learned Counsel for the petitioner, and also Mr. B.K. Sharma, Learned Standing Counsel, Social Welfare Department. In this writ petitions, the petitioner seek directions to respond number 4. The Child Development Project Officer, Tokuakhana, ICDS project, Lakhimpur, for issuing a necessary consequential appointment order as Anganwadi worker in their respective Anganwadi center, following enquiry report 29/1/11. Petitioner had appeared in the selections for appointment as Anganwadi worker and they were selected. As per enquiry report of the Child Development Project Officer, Tokuakhana, ICDS project, dated 29/1/11, the residents of the petitioner have been found to be within the area of the concerned Anganwadi center. Particulars of the petitioner are as under. Petition number 1, 2, 3. Then Lordship may come page number 69.
You from the same area. You are also
No,
the same area.
The basic issue is that Lordship. First,
Presently, we are working, that's what we get order.
that is also I am submitting Lordship.
But we are not made a part.
Yes, that is the fact, Lordship. Initially, these petitioners were appointed, Lordship selected and appointed in the year 2013. They were working. That they have also done their training part. During that period, Lordship, 2 persons approached this honorable court without making this petitioner as party in the said proceeding.
You.
Yes.
This is your order.
And
Yes.
that is why this order Lordship I am reading. In this
Yes.
situation, Lordship, we are not made party. So since we are not made party, the court also Lordship, it was perhaps Lordship, it was overlooked that those were Lordship the necessary party. But court directed to arrange their Lordship consequential engagement order. But without informing this petitioner, without making us party in the said proceeding.
So you-
Immediately, Lordship, after coming to know about their cancellation of our order, we approached this court that since we are not made party in the said proceeding, how our appointment can be cancelled. So accordingly, Lordship, this honorable court, after going through the Lordship entire their submission and records, even imposed cost of rupees 10,000 to the erring respondent Lordship. By order dated 17/12/19. That order just before I have to read out Lordship. So they have paid that cost amount, but we have not been Lordship reinstated in our post. So that is our.
This
case.
order was passed in
The first order Lordship,
second order.
the second was passed in 17/12/2019.
Yes, so when did you
So-
file this writ petition?
It was in 2000, no Lordship,
When did you file this
it was
writ
in
petition?
2021.
Hmm?
21. Since Lordship, the engagement order of private respondents were set aside. Apparently, Lordship, our first appointment is Lordship, it will come automatically in exist Lordship. Because it is like eclipse Lordship, since we were appointed initially and our appointment was cancelled by without making any party in the writ proceeding. So automatically Lordship, our appointment order will Lordship exist. And now Lordship, they have filed this review petition, that item number 2.
You should be. Huh? So when did you, where you have filed this writ petition? Present writ petition?
Present writ petition only to since Lordship,
To
the,
implement the court's order.
yes, no, implement the cost as well as the order of this honorable court.
Hmm?
Cost as well as, since Lordship, their engagement has been set aside by this court, then
Yes.
automatically our appointment will Lordship revive Lordship. So
Hmm.
this is our case Lordship.
That's what I'm saying. When,
Yes.
when you, what is your prayer here?
Prayer is only to Lordship re-engage us.
Indirectly, you are asking for implementation of the court's order.
Lordship, our prayer part is at page number 15. Administration call for records of the case, issue notice to respondent so called has to, why read in the nature of amendment or any other appropriate order, direction should not be issued directly to respondent or to reinstate and re-engage this petitioner as their respective Anganwadi center and also to release their
No,
unpaid
that's what
area.
I'm saying. If your appointment was, the cancellation of your appointment was set aside by this
Yes.
court,
Yes,
then why you have slept over the matter?
so Lordship.
Why you have slept over the matter?
No, Lordship, they were supposed that Lordship, their appointment will be considered.
For how
By the
many
process.
days? How
Mhm.
many years?
It was in within Lordship 2 years perhaps Lordship.
So,
So it was not considered and but Lordship, they have partly Lordship complied with the orders of this court.
it's all right, partly
Yes.
complied. You have received the cost
Lordship, one thing,
and you have allowed it to lie down for more 2 years.
thing is that Lordship, supposing that we were first appointed in the year 2013.
It's
What-
all right.
Yes,
Why you have approached by of this writ petition? That's what I'm
no, Lordship,
asking.
because this petitioner could have approached by filing contempt proceeding also in time, but
Yes.
since Lordship, it was in 19 and 2021.
That's what.
But it
that's what
doesn't
I
mean
said.
that Lordship, their right will
It's
go.
stayed over.
No, Lordship, it doesn't mean
Since
that their right will go, because first thing is that Lordship, once the appointment of the private respondent was set aside.
Then there is equally order of this court to issue an engagement order.
But not against our post Lordship, not against the post of this petitioner.
Ah.
Lordship will see the kindly again see the Lordship. order.
It's a different areas.
Yes, no, Lordship,
What do we call it? Different
They are just-
center, different centers.
yes,
In a Anganwadi center, there is only one post of Anganwadi
Yes.
worker and one post of Anganwadi helper.
Lordship first order will see at page
So
68.
in that Anganwadi center, if Lordship kindly takes up page number 67,
Hmm.
this is the first order.
Yes,
There, my lords, the Anganwadi centers are mentioned.
yes,
Hmm.
Anganwadi centers, Lordship has taken note. at
Yes.
Page number 68. Page number 68, Lord.
Yes.
In that petition, kindly, page number 68
yes,
states, there are 3 petitioners. Petitioner number 1, Devjani Gogoi. We are not concerned with Devjani Gogoi. We are
Chapari.
petitioner
Chapari.
number 2 and petitioner number 3.
Hmm.
One is Pulkumari Peku and other is Gulapi Hazarika. And kindly take note of the Anganwadi Center, Joyrampur, Baghara, Anganwadi Center, and second is Dokhin Pithial Anganwadi Center. So these are the two Anganwadi centers. Then next page, kindly come with us. On 6/5/2013, this floor directed the Lanet Standing Council to obtain instruction as to why the petitioners have not been appointed as Anganwadi worker. Despite the inquiry report dated 29/1/2011, on 6/6/2013, time was sought for by the Lanet Standing Council to obtain necessary instructions today. When the matter is called up, the Lanet Standing Council submits that he has not been posted with the requisite information, and in such circumstances, the court will review that the case need not be kept pending and necessary direction may now be issued to the respondent number 4 to issue necessary consequential engagement order of the petitioners as Anganwadi worker in respective Anganwadi centers.
Yes.
So in respect of these two centers, the Honorable Court is directed to appoint us. The consequential.
Three centers, in this case,
Yes.
three centers, huh?
Lot. So kindly now come to, subsequently, the order is there, at page number 72.
Yes.
Page number 72, the director has said.
Yes,
That this number of the repetition, can you take note of 2324 of 2013, that is that page number 67. Page number 67. He said that in pursuance of the Director of Social Welfare Assam order by number so and so, in respect of Honorable High Court case number 2324 of 2013, the engagement order in respect of order number so and so dated 11/5/2013 of Noyanmani Hazarika helper in Dokhian Pithial Anganwadi Center is hereby cancelled.
Yes. How? It is the question.
No,
Yes,
I will
come.
come. And second order is also there. But Anganwadi Center name is important.
Yes.
Dokhin Pithial Anganwadi Center. And second, kindly see page number 73. that is-
yes, I have seen. Against this only this,
Yes.
he has filed a writ petition.
Yes.
So in the second writ petition, second writ petition, again, the Honorable Court has passed the order at page number 74.
On consideration of earlier order and
Yes.
the records regarding the
Yes.
allegation of, regarding inquiry report.
Yes. The Honorable Court has said the
Your cancellation has been set aside.
Yes.
So what is the next?
Yes.
if the cancellation is set aside,
Yes.
kindly see, if here is the situation that only one post, and there are two orders of the Honorable Court to appoint two persons. In Anganwadi Center, there is only one post. So, in one post, we cannot appoint two persons. Therefore.
No, there are two persons. There are also two persons.
Lordship, they have misinterpreted. Lordship, allow me 2 minutes time. I will clarify the situation.
Yes, wait, I know.
Yes, they have just misinterpreted the provision of.
I'm just asking,
Lordship,
how many petitioners are here?
there are two petitions.
Yeah, two.
Two persons,
Jaipur and Jairampur and one
Dokhin Pithial.
Lokim
And here,
Pitia.
the Jaipur and Dokhin Pithial.
Huh?
Already persons are there appointed. Now the Honorable Court at page 67 has passed an order that appoint them. So we have to, first of all, whoever is sitting in the post, sitting in the chair, we have to take him out and they appoint the person. Otherwise, it is not possible for them to appoint when one person is already there to appoint other person. Therefore, they have pursuant to the Honorable Court order, which Lordship has seen at page number 68. The person who are already appointed, their appointment has been cancelled. And the
The
Honorable
cancel
Court-
has been, this court has set as the cancellation.
Honorable Court has said-
What is the next?
We have filed the review petition. Therefore,
What review?
Therefore-
What is the ground of review?
No, kindly take up the review petition.
What is your ground? You tell us.
Our ground is that only, that in one Anganwadi center, there are two Anganwadi centers, two petitioners. Honorable Court has considering the matter directed to appoint them. So when we are to comply with the order, we have to get the post, otherwise how we will appoint them. So
That is-
therefore,
that is-
in 2019.
See, the second order passed by this court has considered the earlier order,
Earlier order has
Yes,
considered-
consider.
wrongly or rightly.
This aspect of the matter has not. been-
Wrongly or rightly, he has said, it's clearly said, para 50 or.
Lordship, page 677.
Yes. You read para 4.
Yes,
page 77, paragraph 4 and 5, Lordship.
paragraph 4 and 5,
Yes.
the honorable court has said that Mr. So-and-so learned counsel for the social welfare department has made an oral submission that cancellation of the appointment of the petitioners were made by following the direction of this court in its order dated 27/6/2013 in WBC number 2324 of 2013. We have perused the order dated 26/7/2013, but have not noticed any such direction by this court to cancel the
Yes.
appointment of the petitioners, nor any such direction is discernible in the communication of the director made to the CDPO dated 31/8/2013. From such view of the matter, particularly in the context of the oral submission of the Learned Counsel of the Social Welfare Department, there does not appear any apparent justifiable reason to cancel the appointment of the petitioners. An attempt is also made by the Learned Counsel by referring to the document annexed at Annexure 5, page 52 of the expedition, which is claimed to be a final report dated 29/1/2011 of the Circle Officer, Gopakhana Revenue Circle, to take the stand that the cancellation of the appointment of the petitioners was also pursuant to the said purported inquiry report dated 29/1/11. We have gone through the inquiry report dated 29/1/11, but have noticed that in the inquiry report, nothing adverse has been stated against the two petitioners. It being so, a prima facie view is formed that even if reliance is made on the so-called inquiry report dated 29/1/11, the circle report to justify the cancellation of the appointment of the petitioners appears to be misleading.
It's okay, Mr. Nath, that's why I'm asking, what is the ground of review? Wrongly or rightly, it's a view of the court. If it is error, if you say that this view is erroneous, what is the next course of action?
It is, we have filed the review because one thing has not been pointed out, the honorable court at that point of time. That there is in two of them, there are two petitions. And we have to appoint the two persons.
No, that is- see,
Available.
This is not required, because when this writ petition, second writ petition was filed,
But
they have clearly placed on record that the earlier order was passed without making
Yes.
them a party, right? And therefore, and the cancellation is based on the earlier order. Because earlier there was a direction to engage, issue the engagement order.
But-
All right?
But-
Now, and plus the inquiry report.
But-
There was some inquiry.
Yes.
Wrongly or rightly, court has taken a view that there is no direction as such to cancel, right?
Cancellation is implied.
How implied it will be? No, what is
Cancellation may,
No.
cancellation may be implied, but then that has been taken into consideration by the subsequent order of the court in the next petition.
Kindly,
No, what I'm trying to indicate you is, I'm not saying as of now that this is wrong or right. The second writ, the order of the second writ of this court. If you are agreeable, if you, according to you, since only one person can be appointed in a particular Anganwadi center,
Not-
and both this respondent and petitioner were claiming of the one post.
Same.
It is implied also. It is also implied.
Not-
Same post.
Same.
Then when this order, when you have cancelled their appointment order on the basis of the earlier order of this court,
Not-
and court said that there's nothing, there's no direction as such.
Not-
It's an erroneous finding, whatever. So it's a ground for appeal, and it's of 2019. You have filed a review in 2023.
When,
Having said that they have filed this writ petition,
when.
2021.
When, that's, when we proceeded to implement the order, ultimately then.
I understand, Mr. Nath, I understand everything, but that problem is the hiccups is, the impediment is, there's no ground for review. There may be ground for appeal. It should have been a ground for appeal. You could have filed an appeal instead of wasting your time in filing a review.
In my replicable submission, if kindly consider. I have sought for review on two counts. Number one, that against the particular post, when the honorable court has already in earlier round of litigation has directed to.
That has been considered.
I have two submissions.
That is
one.
Sir, that's why I'm saying.
And the second submission is done. That has not been brought to the honorable court's notice while deciding, while passing the second.
Not necessarily. That was, as you said, it was implied.
But in fact, it was not.
Though it has been particularly recorded, but it has been implied, they are claiming for the same cause.
And one of the other persons who are affected, they are also not party. So my prayer is that the review petition, what I am gonna say, just. if lordship
Same
allows-
thing.
If the lordship allows.
He is taken a sweet revenge.
But-
Earlier occasion, they had not made him a party.
Yes.
Second petition, they are equally saying they have not made them party. It's a very
So that,
sweet revenge.
if the
Because
litigation,
the first round of litigation, they have not.
Just wait.
Yes, yes.
one should make submission, he will get it done.
There's a review, so we are hearing the review first.
So if today lordship allows the review petition, so my prayer would be that would be my prayer. And reviews the order dated 17/12/2018, then the petition will be restored and he along with the other person, whatever we have, we can place it before the lordship. So that lordship can pass it after hearing all the parties. Because if in the 2013 petition, they are not parties. They are not parties. In the 19 petition, they are not. And the authority in between, my lord, there are two orders to appoint them also to the private document. So here is a situation, my lord, if we go to appeal, so if we go to appeal, ultimately those things are not brought before the honorable court while passing.
See, why I'm saying that the court has recorded that
There is no.
there's no direction,
Lord, para 5.
but have not noticed any such direction by this court to cancel the appointment of so and so, so and so.
But apparently there is no, but.
This is literally, this has been interpreted of
But
the last.
practical difficulty for us is, if possible to accommodate 2 persons in one Anganwadi center, we have done. But the problem is, Anganwadi worker has to be from the survey area of that locality. We cannot.
They are not.
No, they are, all of them are eligible.
No, you said they have not been made a party.
Yes, madam.
No, they have not been. They are the party here. Golab Hazrika and
Their party was in the state.
Kumari Pegu.
Yes,
But they are not,
party there, party. Their party, for number 6 and 7.
no, in the 2013 petition,
13 because we are not met by.
in the-
They are not party.
without hearing them.
Why not going back to them?
Yes.
That is when, in 2013.
You have filed a review of which
19
19 then.
The second,
So why
They-
not going back to that?
yes, the second order we have.
So I think because they are already a party, they were made as a party, so
Number 6 and 7.
no ground for review.
But there is an order to appoint 2 sets of persons, 2 persons from a team one.
That's what I'm saying.
That is,
What I'm saying is, I'm not saying that you are wrong.
but
Absolutely correct. I agree with you, but then there's no ground to review this 2019 order. You may have a good ground for appeal. You could have done that. That's all. Review dismiss. Come to the writ
Lord.
petition.
So only now the simple prayer is.
Any case law which you would like to submit?
ultimately, I find that, for,
Practice, you are correct. You are in a big soup.
review logic, is very clear, on 3 grounds.
That's
An
right.
error upon the face of the record or to.
I don't find any error.
Or to prevent miscarriage of justice also.
Yeah.
That logic can consider.
Hmm.
But here, my submission, the people's submission will be, the authority is not in a position to proceed, to implement the honorable court order. The authority is ready to implement the order, but there are 2 orders. Therefore, for the second order, in reference of the second, of the review petition to prevent the miscarriage.
Problem is wrongly or rightly, the second order, the court has perused the first order.
2 things, 2 aspects, that is not in my manner. 2 aspects are not considered, that this person cannot be accommodated in a different place. Because the Anganwadi worker has to be from the same survey area.
Is writ petitioners.
Yes, madam.
They are not from that Anganwadi center.
But I am submitting, there is an order of the honorable court to appoint them.
Hmm.
But had it been a case that he can be accommodated in different posts at different place, we would have done by the. Would have more comfortably. But in respect of Anganwadi center, the problem is we have to appoint the person to the survey area only, in that particular center only. And the center consists of only one.
No, if that is the requirements of the law
That is the.
or the rules, how can the court will direct you to appoint them in a different center?
So, Malab, if we implement the 2019 order now, ultimately 13 order will be violated. Because we cannot keep too far. Not to indicate, I take it. I take it.
That's what I'm saying.
I take it. I think-
You are in a soup and you have created this, you could have taken it,
At that point.
taken,
These aspects were, my responsible service is that these aspects were not brought to the notice. My suggestion is that had it been brought to the notice of the honorable court, the outcome would have been different. That is my grounding.
no, problem is that they have brought it to the record.
So, Lordship, may I kindly indicate my grounds for the review petition so that I can take the further action.
Hmm.
My grounds are kindly take note of my grounds for the review petition. I have only mainly two grounds, page 10 of the review petitions,
Hmm.
page 10.
Hmm. Yes.
That while passing the review judgment and order dated 17/12/2019, the honorable court has failed to consider and appreciate that the selection process in question in respect of Anganwadi Center, namely Joyrampur, Baghara Anganwadi Center and Dokhin Pitia Anganwadi Center. The opposite party number 1 and 2 applied for the Anganwadi Center, and for the said Anganwadi Center, the respondent number 6 and 7 in WPC number 2092 of 2015 also offered their candidature. As there is only one post of Anganwadi worker in one Anganwadi Center, when the honorable court by its order dated 27/6/2013, passing WPC number 2324 of 2013 directed appointment of the petitioners, namely Fulkumari Tejwan and Gulabi Hazarika, it is incumbent upon the review petitioner authority to cancel the appointment given to the opposite party number 1 and 2 to appoint the petitioners in WPC number 2324 of 2013. The opposite party number 1 and 2 can be accommodated only in the post of Anganwadi worker of the respective center, wherein Fulkumari Tejwan and Gulabi Hazarika were appointed. Although the Fulkumari Tejwan and Gulabi Hazarika were present before the honorable court in WPC number 2092 of 2015, at the time of passing of the order, this aspect was not considered. Without terminating the service of Fulkumari Tejwan and Gulabi Hazarika, the authorities are finding it difficult to appoint the petitioners in WPC number 2092 of 2015, as only one post of Anganwadi Center has as only post of Anganwadi centers have been occupied by the opposite persons. Therefore, the judgment is liable to be reviewed suitably. And the second ground, I have said that the honorable court failed to appreciate that for being appointed as Anganwadi helper or Anganwadi worker, a candidate has to be a local resident of the area where the Anganwadi center is situated, and they cannot be appointed in another Anganwadi center. As the Anganwadi center in question already consists of an Anganwadi worker and an Anganwadi helper, it is not possible for the authorities to appoint the petitioners without removing the persons who are holding them. Therefore, the judgment and the dated 17/12/19 is liable to be reviewed suitably.
So who is working right now?
As per order of 2013, they have been lordship engaged. Now they are working. But since lordship, their order has been set aside, even after their order being set aside, still lordship, the respondent has allowed them to work. That is the lordship case.
Which
Their order
order?
has been set aside by the honorable court. Despite just being order being set aside, still they have been allowed to work lordship in the said post.
Their appointment order has not been set aside. Your cancellation has been, the appointment.
Yes, meaning thereby,
The cancellation of your appointment has been set
Yes.
aside.
so meaning thereby lordship automatically thereby cancelled. We have been
The
lordship.
problem,
we have
your problem is also why you have not approached this court in time, within
No.
time.
two aspects is lordship. First thing is that the order was passed in 19. So in the meantime, lordship, they have partly complied with, that is lordship, they have paid the cost imposed upon the
Yes.
respondent. Yes. They have caused the cost part they have complied with.
Hmm.
Now we are under bona fide presumption that since they have complied with the order they have paid their cost, they will definitely lordship re-engage us.
When did you, when they have paid the cost?
Lordship, after passing the order, lordship, the date exactly I cannot say lordship. but
Then?
Yes, but they have complied. They have paid the lordship cost.
Hmm.
So now lordship, the second part lordship, they have not complied with. That is why
That's
lordship
what I'm
is-
saying. Second part, if it's not compliant, what is the procedure?
No. procedure of writ proceeding is there because first, since the right of this petitioner has been revived, Lordship, by the order of submission of the court.
Hmm.
So, Lordship, it will, although, Lordship, they could have filed contempt, but
Then
writ proceeding also maintainable because, Lordship, their right is still exists. Lordship.
what right? Already
re-examine
this,
them, Lordship,
this
because
court has
that-
already interfered with your the
Yes.
cancellation and
Yes,
what else we should sit over the matter again and again.
no, Lordship, because, Lordship, they have, now the question of 226 will come because they are not, Lordship, considering the order of the court and they are not acting as a, Lordship,
Hmm?
responsible officer.
Hmm.
So, Lordship, 226 will come, Lordship.
What is this? Huh? What is this? Annexure 6? Page 32?
Lordship.
Oh, this is a review petition.
Lordship, taking up review petition.
Yes, review petition, what is page 32?
Page 32.
Yes,
Page 32 is a repetition.
Hmm.
It is filed by a third person. If there are three persons, my lord, kindly if takes up 23, page number 23 of the review petition. The first order of 2020,
Hmm.
petitioner number 2, Devjani Gugul,
Which one?
page number 23, relevant is page number 23.
Review petition.
In the review petition, page number 3.
Hmm.
Logic will find petitioner number 1, 2, 3. Three petitioners were there, one Devjani Gugul.
Yes.
My lord, we are not concerned with petitioner number 1.
Hmm.
We are concerned with petition number 2 and 3.
Yes, yes.
I have indicated Devjani Gugul, petitioner number 1. She has filed a writ petition in the field in 18.
Huh.
And subsequently there was also a review. Well, just to explain the delay, why the process was delayed.
This is what order?
This is in that particular.
First one,
Yes,
Lordship, the first order,
writ petitioner in the first writ
first,
petition.
yes, there is
Petition number 1 in the first writ
Yes.
petition. Yes, yes, then.
yes,
in fact, in this case, we are not concerned with that, only to explain the delay, why there is delay in filing this petition. That we have.
no, Lordship, this order will say, Lordship, what was in the 2013 writ petition, Lordship. Because the 2013 writ petition was again, Lordship, reconsidered by this court and it was disposed of, yes.
Both the petitioner number, there's a number 7, Srimati Lilimai Borua participated in a selection process with advertisement available at the lecture 1 to the writ petition amongst others for the post of Annampati helper in Kupong Sapori Annampati Center.
Yes.
Without delving the long checkered history of litigation.
No, there was a claim and counterclaim between Gogoi and Borua.
Yes,
So what had happened?
yes. Ultimately, kindly take up my para number 6, page number 12. There I have
Hmm.
of the review.
Hmm.
The petitioner respectfully states that the petitioner number 1, Devjani Gugul in WPC number 2324 of 2013 has preferred a review petition before the honorable court, being numbered as review petition number 21 of 15, and the said review petition was disposed of by the honorable court by an order dated 30/5/2017, whereby the order dated 27/6/2013 in WPC number 2324 was recalled and the writ petition was considered afresh. That order I have annexed.
Hmm.
Logically find that order. Then, and the writ petition was considered afresh after the order dated 35/2017 passing review petition number 21 of 2016. The writ petition number, the writ petition 2324 of 2013 came up before the honorable court on 21/11/2022, and the same was disposed of by the honorable court, considering the fact that in the intervening periods, the Director of Social Welfare Assam had conducted an inquiry and verification and arrived at conclusion that between the two, Lilimai Borua, while designating Anganwadi worker of Kupong Sapori Anganwadi Center,
Where you are reading? Sir,
page number 13 I'm reading,
13,
1
of.
of the review petition.
Hmm.
The logicals I'm, the paragraph six starts from page number 12.
Hmm.
I'm reading.
So Lily Barua has been appointed.
Clearly.
So there's no issue.
No, there is no issue. And
So why you have filed,
I
brought
have-
on record
I have
to show that that there's no delay because because of this.
paragraph number 6 and 7, I have explained.
Hmm.
Why? Because the matter was, connected matter was pending and the file was moving in that way to explain that why the process in filing the review petition tells.
Okay.
Lordship. So lordship, such kind of explanation of delay lordship that cannot be considered because they have to come in proper appropriate lordship procedure.
Delay,
First
delay,
thing, yes,
when-
delay will not come.
delay.
And thing is that lordship, the order they have annexed, the first order lordship passed in 2324/2013. It was lordship recalled by this honorable court and lordship will see that order, the recall order, lordship will find at page 28.
Then anyway,
Yes.
you tell us
There-
if there is one post,
Yes,
two orders,
yes,
conflicting orders,
yes,
which gives the authority to direction to engage them,
yes,
and your cancel on the pursuant thereto, the cancellation, the order has also been subsequently
yes,
interfered by this court
yes.
in one post. What's the way out?
No,
Tell us.
the first way is that lordship, because we have been initially we have been appointed on the basis of merit. Because they didn't
There
deserve,
is not the issue.
no, the first thing is that we were appointed on merit basis. That order was challenged by the two respondents without making us party. This court only directed to,
No, who has appointed? The state has appointed.
yes, state has
State
appointed.
was-
State has
state was
appointed.
heard.
No, lordship, state has appointed this petitioner.
The state was heard.
Yes, that is what I'm saying, lordship. The
Yes.
state has appointed us on the basis of the state comparative statement prepared by the selection committee. So we are on merit basis, we were appointed initially.
Well, not wrongly, rightly, there's a two orders.
Two
Which
orders.
is in favor of the respondent and other is in favor of you.
So, yes.
It has to be appointed in one post, so.
So now the only lordship way is to find out this problem, to overcome the situation is that they could have lordship, they could have reconsidered the comparative statement prepared by the selection committee, and on the basis of selection committee lordship, they could have appointed this person who are more deserving. They have not done anything.
They will say tomorrow that you have violated the court's order. Wrongly or rightly, there's a court.
No, because the court has not directed to cancel our appointment. First thing is that. In the first,
See, problem is,
the problem is
there's
that
one post.
that is
I mean,
why
two
lordship,
posts.
before cancelling our engagement letter, they could have lordship make to review what this order of this honorable court as well as the appointment of this petitioner. They have done nothing lordship in the year 2013.
See,
Straight away they have to cancel our engagement
Court-
order.
orders are not passed on the air.
Yes,
Wrongly, rightly, there's two orders of this court.
yes,
One in favor of the respondent,
yes,
other in your favor.
yes,
And the appointment is to be made only two posts,
yes,
or two centers.
yes,
There are four persons.
yes.
What is to be done?
Because the way is clear lordship, because after cancellation our engagement lordship, we have approached this court. Then this honorable court lordship set aside the cancellation order of this petitioner, meaning thereby lordship their appointment has been cancelled by this honorable court. So picture is clear lordship, because they are just trying to lordship accommodate those persons who are there favorable. Nothing more lordship, because
You are, in that case, you are supporting the
No.
review petitioner.
no, they,
If you
I
are, if you are saying so, we'll allow the review and
the
recall
thing
this
is
order
that
and we'll
they have
we'll
not-
restore your writ petition.
they could have.
We'll hear it.
No, lordship, they could have filed review petition against the first order, because in the first order of this honorable court, we are not made party. So they could have reviewed that, or they have not done the review of this order. Immediately, lordship allowing this review petition, they will say that your party is already over, the court has reviewed the order. That's the will they take. But thing is that lordship, why they did not file a review petition against the first order of 2013? Because that order, in that order, lordship, we are not made party, despite without making our party lordship, they have cancelled our citizenship.
That you have already
Yes.
filed.
The lordship may do one thing, lordship may call for the entire records of 2013 case and 19 case also, lordship. And on the basis of the comparative statement made by the lordship selection committee, lordship will give the findings who will be more deserving. I think it will be better, lordship.
In that case, we'll allow the review and we'll hear you, both the parties, In,
No.
and restored your writ petition, earlier writ petition and very on merit. Who is entitled, who is not entitled?
No, no, Lordship, then
Alright.
Lordship may allow us to file our objection because they have
What
not-
objection?
in the review petition because review petition they have filed after 4 years without explaining any.
Then why you have not asked?
No, Lordship, if Lordship allow us to file our objection in the review
Almost
petition.
45 minutes you have spent on it.
No, Lordship, first thing is that the review petition is not maintainable because they have filed without filing any application for condemnation of delay. So straight away they cannot come for review of order after 4 years or 5 years. First thing. Second thing is that the ground they have sought, the ground they have mentioned in the review petition and the annexer, Lordship will kindly see. The first order of 2023 was recalled. Lordship will see the recall order first.
You have given the delay?
Not,
Explain the
not
delay.
allowed, Lordship. No.
In the petition, Lord, I.
No,
In
no,
review,
it's
in
not
review,
different. I
yes.
know, I'm
Review petition is
conscious.
different issue.
I am conscious.
Yes.
Explanation.
Have you have
Explanation
given the
different.
explanation?
Para six.
Yes. That is
16.
not enough, Lordship.
It's enough. If we
No, Lordship, in
explain
review
it.
petition, Lordship, that is not enough, Lordship, because the
Sir, it's a writ proceeding, there's a judgment of this
review is
court.
different, Lordship. What I have understood, Lordship. review is-
The principle of
Yes,
the Limitation Act will obviously apply.
yes, in
But
review.
there's
petition.
no requirement of filing a separate revision, the IA for condonation. Only he need to explain it.
No, Lordship, they have also not even,
There is a judgment.
they have not even explained, Lordship, that why.
They have explained. That's why all these,
No,
Para 6 and 7, I have.
wait, no, Lordship, you can see the para 6 and 7, what they have explained.
Then my explanation is sufficient or it is for
How-
the four.
Mr.
It will Lordship just.
Review,
get
huh?
administrative
First-
proceeding, Lordship, and
First
they will
review.
just.
Heard, no, heard Mr. in writ proceeding, heard Mr.
Jay Kolika, Lordship.
J. Kalita, learned counsel for the petitioners. And also heard Dina, learned senior government advocate for state respondents, and Mr. PJ. Seke, learned counsel for the respondent number. Oh. Let's go. Having considered the state has filed a review petition against the order of this court. A review petition to the order of this court. Dated 17/12/2019 in WPC 2092 of 2015. The review petition was taken up first. Is request to be taken up first. Next paragraph in review. And then therefore, this court has proceeded to take up the review petition. The review petition number 136 of 2023. Next paragraph in review petition. In view, I heard Mr. Did not learn a senior government advocate for the review petitioner and Mr.
Jay Kolika, Lordship.
Jay Kalita, learned
For
counsel
respondent
for the opposite party. You are also here, and Mr. P.J. Seke Swings.
In a repetition, I was not made party.
No,
No.
you are there. You are there. Can we go through?
Yes.
I-
Yes,
They were there, Lordship.
yes.
No, in item number 1.
Item one,
The present item number 1 is not there.
item
Huh?
one, they are not present because
Earlier,
either represent your party, Lordship.
Okay,
Yes,
in the present petition, item number 1.
okay.
because their presence is not necessary because we have,
Again, though in that case, in this present writ petition, you are not a party. Okay,
Yeah,
don't
this
you
is
delete
not
that in
it.
the writ petition.
only, in-
So again, another problem.
they are not necessary party, Lordship.
I think it's a case made
No,
out
Lordship,
for
they are not
rev-
necessary party.
review.
We have not challenged, we have not sought for any relief against them, Lordship, because they are not necessary party in the present writ petition.
Huh?
In the present writ petition of 2021, they are not necessary party.
Ah.
Only against the state respondent why they are not acting up as per order of this court, Lordship.
Uh,
In 15
In that
requisition,
case,
they are filed.
so and so. You delete his name in the writ petition. Is it okay? In view of the order passed in WPC so and so, so and so, this writ petition, this review petition is taken up for consideration. I'm allowing the review
Lordship,
petition.
fixing a date for hearing of this, my first requisition, Lordship, of 2015.
Hmm?
Yes, Lordship, that can be allowed, Lordship, and fixing a date for final hearing of this, our requisition, Lordship. No, otherwise, Lordship, we have to find out a way to how to, Lordship, settle this issue.
The same thing. Well, we'll have to practical. I don't find any ground for review.
Yes, nothing is there.
But
Lordship.
then, what would be consequences?
Yes,
that it?
consequences. Because everything that the ball is in their court, Lordship, they can do anything. That is the problem, Lordship. The
Okay.
13 requisition, they have not come for review. In 19, they have come.
So, review allowed
Yes,
will restore the earlier writ petition.
Lordship.
And in view of this,
Yes.
the present writ petition is closed.
Not close, Lordship.
Close.
Lordship, no, Lordship. Along with the earlier requisition, Lordship can take up for consideration.
So
Whether we are entitled for,
what new things is there?
no. If Lordship allow us that requisition,
Since we allow the review and restore the earlier writ petition,
yes.
this present writ petition arises out of the order of this way.
Lordship may fix a date for final consideration of our requisition. Otherwise, it will take another 2-3 years, Lordship.
Huh?
Fix a date, Lordship.
Let me pass and sign the order, then consequences will follow. All right. After you get the order of this court in review petition, you
Yes.
make a mention.
Ah.
All right.
I'm
Let me pass the order and sign it, and then consequences will follow.
Loss. Otherwise, Lordship, this problem will not solve because,
Privacy, I don't find any ground.
yes, nothing is there, Lordship.
Because of the interest of the
Yes,
thing,
the
I'm
complexity
taking
of
it
the
a
question.
little lenient view or review of the matter.
Cost may be imposed upon this respondent.
So that is the.
In a review petition, because Lordship,
And all the time we cannot.
yes.
All the time we don't impose cost.
Because we are suffering, Lordship.
To prevent the miscarriage of justice, that is not my ground. I'm highly.
No, only on that only. Otherwise, there's no technically there's no ground.
There is no ground loss.
No,
Yes.
there is apparent.
I'll observe that.
Loss. That may be observed. Yes, Lordship.
Madam, may kindly take note that.
Anyway, I have no
To
say.
miscarriage of justice, given.
No, I'll. That's why I say I've already allowed.
Loss.
For any other sufficient ground.
Ah.
Not, problem.
Any other sufficient word will not suffice loss.
Ha. That will be again, another order will be there. Real 4 taken at the 3, 4 and 5, no? Yes, 3. Yeah, both 1 and 2 disposal, huh? Huh. No, repetition will be disclosed in view of the order in the review. Quiz for respondent. At least respondent should be there. Quiz for the states. Non appears for the petitioner on call, comma. Airport state. Huh? Huh? Who is respondent number 4? Who is respondent number 4, madam? State level committee for appointment on compassionate ground. Huh? Okay. Non appears for the petitioner on call. Next para. MS. A Talukdar. London State Council appears for respondent number 4. Who else are there? You just write that non appears for the parties, non appears for the petition as well as for respondent number 1, 2, and 3. Mr. However, MS Rancho appears for respondent number 4. Method relates to this writ petition has been filed challenging the minutes of the meeting dated 31/12/2018 passed by the 2018 of the state level committee rejecting the claim of the petitioner for appointment on compassionate ground. List of the petitioner claims that next para, his father, his late father Babulal Thapa, while serving as stenographer grade 3 in the office of the superintending engineer PWD Haplong NEC Circle, Haplong, had died in harness on 07/03/2014. Listed. He being the eldest son on 10/06/2014 applied for appointment on compassionate grounds. List of accordingly, the district level committee in its meeting held on 13/11/2011 recommended his name for appointment on compassionate grounds. List of however, the case was not placed before the state level committee. List of being agreed for non-placement of his case, he has filed a writ petition being WPC. Where is that writ petition? Seventeen. Being WPC 1581 of 2017, which was disposed of on 07/04/2017, directing the placement of the petitioner's claim for compassionate appointment before the next state level committee. Yes, Mr. We will record that. Next para. Thereafter, the case of the petitioner was placed before the state level committee. Where is the first consideration? Where is the rejection? First rejection?
Second edition, number 7 or
No. First is that 31/12. 12 to 16. No, 1226 is the Hira Tafa. What is the decision in his case? The DLC recommended his case for appointment on compulsory ground in the vacant post of peon shown by department, subject to appointment for person against 20 years, relating to government OMC. Where is the finding? There is page 20, madam. Where is his case? Next. Thereafter, the state level committee has considered all the cases for appointment on compulsory ground. And by by the impugned minutes dated 31/12/2018, the case of the petition was rejected on the ground that the recommendation for his appointment on compulsory ground does not fall within the 55% quota as recommended by the district level committee. Mr. Next paragraph. Where is the second consideration? Where it is? Page
Point number 40. Page number 40.
affidavit in opposition. Where it is?
Page number 7.
Underqualified. Next paragraph. It is noticed that no, next paragraph. The petitioner, the respondent number 4 has filed the affidavit clearly stating that the case of the petitioner was considered by an impugned minutes dated 13/12/2000, same order, and rejected on the ground of that his case does not come under 5% quota for appointment of compulsory appointment. In the as recommended by the district level committee. Mr. The case of the petitioner has also again considered for the second time on 15 by the minutes dated 15/02/2022 for consideration of his appointment on compassionate ground in grade 4 post. However, the petitioner found to be under qualification. Therefore, his case has not been it has been rejected. Next para. Having considered the grounds of rejection, firstly, on not falling under the 5% quota for appointment of for appointment on compassionate ground. And also the second consideration and its rejection on the ground of underqualification. This court is of the view that the consideration appears to be not inconsistent. No, it appears that there's no consistency in the consideration. Prime facie of the view considered that no, the consideration by the state level committee appears to be no, there is no consistency in the consideration by the state level committee. Mr. However, since there is no representation on behalf of the petitioner, I'm of the view that the petitioner may not be interested to pursue this matter. Next, accordingly, the petition stands dismissed for non-prosecution. Because yes, anybody?
May please allow.
Yes.
But in this matter, we have to receive certain instruction. Most probably the person has been promoted. And secondly, my lord, the office memorandum which was on the challenge has been substituted by a new office memorandum. So two issues, my lord. You'll require a week's time to inform my lords. Most probably the person has been promoted, lord.
We'll close it, give you a liberty, because the notification which you have challenged.
Challenge, my lord, that has been substituted by a new one.
Then-
So lordship, that
then
is
nothing
two
remains.
aspects, lordship. The person most probably.
The basis goes.
Mrs. goes, lordship. So we'll have the instruction, lordship, maybe tomorrow day after, lordship, because Mr. Senior Advocate DK Das is not there. He's on leave, lordship. Lord, I could not contact the client, lordship.
You
If
contact
he has
the
been
client.
promoted, the grievance also would have been settled, lordship.
Mhm.
That is what.
We'll take it up the day after tomorrow.
Day after, my lords.
We'll take it
I'm
up.
obliged.
Because if the basis goes, nothing.
Yes,
can-
my lord, that is what. I've submitted it fairly. lordship.
On the prayer of Mr.
H. Detala, lordship.
It's better along counsel for the petitioner. List this matter on 2030.
No, lord,
30.
Friday,
Huh?
day after tomorrow.
Ah,
lordship.
2005, 2025. So as to enable him to obtain instruction from the petitioner as the basis of the basis of claim. Notification dated what?
18/1/2023 is a new one, lordship.
No, old one,
The earlier one was 3rd August 2016, lordship.
3rd August 2016
16,
has been substituted by a new notification
18/1/2023, lordship.
dated 18/1/2023.
1/2/23, lordship. Will receive instructions. I'm deeply obliged, my lord.
Yes,
But we couldn't, I think for 10 days, I.
Yes. You are for?
PK Ghosh and we have CK Ghosh.
No, you are for petitioner.
PNRD.
No, no,
PNRD.
Huh?
PNID.
What affidavit?
And your lordship, on last order also this one directed to file affidavit, my lord.
Affidavit is required.
Yes, my lord.
Yes, heard Mr. So and so, learned counsel for the petitioner.
PK
Next matter. Mr. Ghosh,
Ghosh and we have
Cake war, my lord.
K Court, learned standing counsel, PNRD. Additional government,
Addition AC.
senior, additional advocate general. Press for is granted 3 weeks time to file affidavit.
Deeply obliged. my lord.
The teacher is supposed to file the rejoinder for the last one.
What is the method? Yes, sir, what is the matter? Seniority. Not appears for the petition on call. Mr. So and so, learned counsel so and so appears. List after 4 weeks.
Yeah, please, your lordship.
Yes,
I have instruction not to pursue this case, nothing. In the meantime, my client has got an appointment in another.
you could have informed the learned senior counsel unnecessary and. Okay, okay, okay.
Yes, go.
Mr. So
M.
and so,
Govind.
learned counsel for the petitioner.
13.
No, police.
I'm a best student, no?
And counsel for the petitioner submits that the writ petition has, he has an instruction
Not to pursue.
not to press this writ petition, as the petitioner has, the grievance of the petitioner has already been redressed.
No, lordship.
He has already somewhere. He has
No,
already
acha, acha.
Also, he has
Okay,
got.
instruction not to press this, writ petition, Mr. Therefore, he pressed that matter may be closed. Next para. Mr. T.J. Mahanta, learned senior counsel appears for respondent number
5 minor.
5. Next one, in the above. No, accordingly, the next para. Writ petition stands dismissed as not pressed.
Problem.
I am sorry, what are the item number 11?
Yes,
I was for respond number 7.
so.
To my present position, I find the ability.
You read?
Respond number
T.
7.
Mahanta for respond number 7.
I find the ability.
What is there? It has not been settled.
7.
Seniority has not been settled.
By the, I think, well, the case has already been settled because he got the promotion, whatever he was claiming that over to me, he has already been considered. So I think that there is no case at all. But even then, let them come and say everything.
Wait, Mr. Lordship.
Yes.
Look, this is an offshoot of some other matters. If your lordship kindly sees, my lord, the original orders, your lordship will see at page 84, my lord.
Hmm.
Page 84, In fact, if your lordship kindly turns to page 93, your lordship will see, my lord, these were ad hoc workers who were replaced by page 93. They were ad hoc workers who were replaced by another set of ad hoc workers.
Yes.
Then we came before this honorable court, and those writ petitions,
This
my lord, will
93 is replacement order.
replacement.
Yes, against
So-
this you came this before
Yes,
this court.
we came before your lordship, my lord,
Then,
and the writ petitions, my lord, will find at page 16, my lord. Page 16, I have given the details. Now, when we filed these writ petitions, page number 16, the government came up with an executive instruction trying to justify the replacement.
yes,
And my lord, my case is executive instructions cannot supplant the law laid down by the Honorable Apex Court, that Piara Singh judgment, my lord. Ad hoc cannot be replaced by another set of ad hoc workers. That is the ground taken. But my lord, pleadings insofar this writ petition is concerned is complete. But this matter will ultimately have to be heard together with the original writ petitions, my lord.
what is the original?
my
That
lord,
is regarding, you are challenging this replacement.
my lord, my lord.
Why this writ petition?
Because when we challenged that writ petition, my lord, they produced an OM, which your lordship will find.
You
my
are
lord-
challenging the OM.
Yes, my lord.
Okay.
And those
Mr.
writ petitions,
So
details-
counsel for the petitioner submits that this writ petition is an offshoot of the earlier writ petition. No, batch of writ petition. Bunch of writ petition.
bunch, my lord, bunch.
Leading being WPC 8619 of 2018, wherein the challenge to the replacement of the petitioner by another
Set of ad hoc
set
workers.
of ad hoc employees is under challenge. The method, the present writ petition had to be filed in view of the notification issued by the state. What was saying what?
My lord, that my lord will find at page 110. It's an 110, my lord. It's an executive.
Notification dated 08/10/2018 seeking retrospective disengagement.
This
It is his.
Disengagement to the petition. Therefore, he pressed that this matter may be listed along with WPC. Along with the above, along with the bunch of writ petition, leading being WPC 8619 of 2000. Please, next, Mr. Goswami, learned additional senior government advocate. What do you want? He appears for the state, huh? Who agrees with the submissions of learned counsel for the board?
Submission for.
No, so far as so far as the listing the matter with the other writ petition. Come on. The prayer is in view of the book, let this matter be taken with writ petition so and so, that 861. All right, list after 4 weeks.
obligement, deeply obliged.
17.
Here the grievance of the petitioner was against his transfer, which was done before the transfer policy itself. But today he has informed me that a petitioner has perhaps taken voluntary retirement.
No,
Pray for a week, my lord, just to find out. from him.
tomorrow, day after tomorrow.
Day after tomorrow.
Huh?
Day after tomorrow.
Our Mr. R. Majumdar, learned counsel for the petitioner. And also, and also have Mr. A.K. Datta, learned CJC for the next page. Mr. A.K. Datta, learned CJC by placing, A.K. Datta, by placing the, what is that?
আপোনাৰ হাতত এখন কি কাগজ কৰিছো?
You want to place that? You want to place that paper here? You want to place?
I want to inform the court there.
Yes, by placing the communication dated 2024. Okay.
He has
that is
not been in
the,
touch.
2024 by the AC within bracket law within bracket NES at GC Guwahati Office of the IGP, CRPF submits that petitioner has no, petitioner has already no, petitioner has, the respondent authority has already accepted the voluntary retirement of the petition. Therefore, the writ petition has become infructuous. Mr. R. Majumdar, Learned Counsel, on such submission, waits for a day's time to obtain instruction. Mr. Accordingly. let's
No, no, I
matter
have
on-
got my instructions. We can have the matter closed. I just got the instruction. I sent him a message.
Okay,
He's given me a message.
okay.
Can be closed.
Then in that case, having considered that the petitioner, the challenge made in this writ petition is to the transparent posting
Transfer and post.
of the petitioner. And by now, the petitioner has been released on being.
It is on voluntary time.
He has gone on voluntary retirement. As well as agreed to the land council that the parties, the writ petition, there's no live issue to be adjudicated. Accordingly, the writ petition stands closed as infructuous, dismissed as infructuous. Huh?
Same order was there.
Obviously, it will go.
Oblige.
May I
Yes.
please your lordship? Lordship, in their lordship, petitioner or home guard. Thereafter, petitioner were home guard, lordship. Thereafter, they are deployed in SPO lordship. And thereafter, on 2017, the from the duty lordship, the SPO has been released, lord. And thereafter, we filed a various representation to regularize our post, your lordship.
It's very strange. We cannot. Your you are a home guard.
Yes,
It's a regular post.
no,
Then-
that's not regular.
Your prayer is to create a new battalion.
No, lordship, to regularize our post, lord, since we have.
No, that
worked,
by raising a new battalion or appoint them in NSU, can we?
Lordship, since we are working from 1996,
Doesn't matter. What is home guard?
lordship,
Who has appointed you?
lordship deputy.
Where is your appointment order?
Lordship, it is in page number 19, your lordship.
Huh?
That is on page number 19, your lordship.
90.
Lordship,
19.
19.
19. Appointment. Where it is?
Home guard, lordship.
Sarjan Hawk has been appointed an officer a member of the Home Guards under Section 3 of Assam Home Guards Act, when lawfully on duty, he shall have the same. What is the nature of this appointment?
Natural lordship page number 12.
It is under the Home Guards Act 1947 lordship.
Yes.
It is categorically status for 6 months only.
Hmm.
The act is itself clear that it is for 6 months.
Hmm.
And his appointment was made under section 6(3) of the Assam Home Guards Act 1947 lordship.
Yes.
Assam Home Guards Act 1947 stated, section 6(3) stated that every officer and every man of the Home Guards shall receive of his appointment a certificate in the form of annex to this act under the seal of the commandant general in the case of the offense of officers and the commandant in the case of the man by virtue of which the person holding such certificate shall be vested with the power to prevail of a Home Guard person. It is the law, lordship. And lordship, section 7, subsection 2.
Why I want to say,
Lordship,
I am asking, what is the nature of this appointment? How they are appointed?
section 6 for 6 months.
What is the provision?
Yes. this
Only
is
for 6 months?
Yes.
What is the provision?
Section 7(2), subsection 2 of the Home Guards Act 1947.
Ha,
It is ruled.
saying what?
It is saying the subject to any rule made in this behalf, a Home Guard may be required to undergo for a period of not more than 2 months such training and may be prescribed, after which he shall serve as a Home Guard for a period of 6 months, which period may be extended by the state government to a total period not more than 12 months if the state government considered as such extension necessary, and shall thereafter serve in the reserve for a period of 3 years, and while in the reserve shall be liable to be called out for duty of at any time. It is 6 months for their duty, and after that they kept the reserve, lordship. It's a reserve force, lordship. Lordship is a volunteer organization, lordship, which created to assist the police, lordship, the regular police force, lordship.
So what are you now?
Now,
This is of 2006.
6.
So,
Thereafter, they have taken as a SPO lordship.
no,
say
that
S-
law says once you are appointed as Home Guard, you
No,
can
lordship,
be engaged.
SPO post were regularized post, lordship.
Huh?
SPO post were the regularized post, lordship. SPO post,
What is the basis of your claim, sir? Tell us.
lordship, the SPO post was the regularized post, lordship. That is on page number,
It's okay. There's a law permits that you can be engaged to assist them in some other job also. I mean, in the police. Tell us something so that we can grant you relief.
lordship, relief has been granted, lordship. That is on page number,
Already granted.
yes, lordship. That is on page number 83, your lordship.
83.
83.
Yes.
Lordship, similar case, your lordship. Only the representation has been.
Where is the speaking order?
Do with.
We have speaking order was what?
We have challenged the speaking order.
Speaking order,
It is page.
Have you challenged the speaking order?
no, lordship.
No.
Then court has directed to dispose of your representation. And you are strangely saying that the relief has been granted. Sir, be little careful.
Sorry, lordship. Sorry, lordship.
What is this? What is this?
Yeah.
Consideration?
Consider regarding the speaking order.
There
lordship.
will be no further extension, huh?
It is lordship. Let us see. Annex I, page number 1, running page number 106 of my affidavit.
Yes, you challenge this.
Yeah.
You withdraw and file a fresh, will grant you a liberty. as per the order of this court, right? Are you challenging this speaking order?
No.
Then
I'm not telling you.
already court has granted, they directed, and on that basis, they wrongly or rightly, your case has been rejected. What is it says? More of the honors of
In light of the above fact, the plea of these petitioners.
seeking reappointment SPOs has no grounds for, yes, you challenge this. Heard Mr. So-and-so, learned counsel for the petitioner. And also Mr. J.K. Goswami, learned additional senior government advocate for the state respondents. Next para. Mr. So-and-so, in view of the speaking order dated 26/05/2023, passed by the Inspector General of Police within bracket A, capital A, bracket close, Assam, rejecting the claim of the petitioner, claiming, rejecting the claim of the petitioner seeking reappointment as SPOs pursuant to the order of this court dated 25/11/2022, passed in WPC 7479 of 2022. You are same persons. Earlier also, this Simanta Das and 35 others?
Yes, Lordship.
Okay. Mr. So-and-so learned counsel fairly submits that he may be allowed to withdraw this petition with the liberty to challenge the above speaking order, if so advised.
Lordship, otherwise,
The next paragraph. In view of the above, the writ petition stands closed or withdrawn with liberty as paid for. You, if you want, you may challenge that. Wrongly or rightly, your case has been considered. Yes. This is yes. Yes, this has been all along, it was before the division bench.
Yes.
And since the petitioner has
He has know, this claim with regard to the rules, now he does not challenge the rule. So therefore, this or particular case, is before your lordship.
You filed the affidavit.
I filed the affidavit, in fact, he is not eligible in terms of the rules. Because the new.
Where is the petitioner?
Malad,
Has it been put to notice? Okay, Mr. B. Sinha is there.
lordship may take it after.
Not appears for the petition on call, Mr. Talukdar. A. Talukdar, S.K. Talukdar, Land Standing Council,
For the department.
Corporation Department is present. Pleadings are complete,
Reading, sir.
pleadings are complete. List after 4 weeks.
Malad, or less. If you are.
May I please, Your Lordship?
Yes,
Some time may be given to obtain instruction receipt regarding letter dated 18/12/2023. Some time may be given to obtain instruction from the petitioner lordship regarding letter dated 18/12/2023.
regarding
Letter dated 18/12/2023.
where it is, what is the letter?
The earlier occasion PWD has submitted that the claim of the petitioner has been rejected by the order dated 18/12 by letter dated 18/12/23. Lordship.
1812. Where it is?
Lordship, earlier on order dated 11/9/2024. Lordship, it is mentioned.
Of the court? Huh?
Lordship. Court order dated
9? 11/9?
11/9/24. Lordship.
Respondent have taken a decision regarding claim to the for regulation, the same has been convened by the business may be given submitted. Yes, where is this letter? 1812. PWD, who is PWD? Huh? Yes, this letter dated 18/12/2023. What is your prayer?
Regulation of service of the petitioner.
So your regulation has been rejected.
Lordship.
What is this 18/12? 18/12/2023 letter.
We had to take instruction Lordship in that regard.
No, no. No, no. This is wrong. This is a communication, this 18/12/2023 is a communication by the Deputy Secretary to the Government of Assam to the Learned Government Council, saying that in view of the Office Member 16/12/2012, as well as the Upen Das case, the case of the petitioner cannot be considered. That is what I say. Okay. No instruction is required. We have to argue. That is there. They have placed the instruction. I mean, government has taken their stand by of instruction saying that in view of all this, your case cannot be considered.
Lordship,
So
sometime
where's
may
the
be-
question of instruction?
Lordship, I may be allowed to call my senior Lordship.
He may be given sometime the obtention. We'll take it after some time. Either you argue it or if not, we'll close the matter. If you don't argue. Yes, what is to be done? See, they are claiming seeking regulation. Your stand is they saying that in view of the office memorandum as well as which has been passed or issued maybe pursuant to the open DAS. His case cannot be considered.
Take it up next Tuesday. Objection also there.
Okay.
For hearing,
On the prayer of Mr. AMS.
The
Science
doctor.
Learned Council for the petitioner. This matter after a week, so as to enable her to obtain instruction from the instruction from her client, from instruction from the petitioner. As the respondent authorities had already taken a decision regarding the claim of the petitioner for regularization, which has been communicated by dated 18/12/2023, rejecting his claim.
Bless Lordship.
Plus six.
Mr.
S committee.
Both you right? Both
Bless Lordship.
are present, huh?
May it please your Lordship.
Yes.
Lordship, in this cases, the respondent have filed their objection, so kindly grant us 3 weeks time to file our affidavit in reply.
What is the matter?
The matter is for the recruitment post of the constable under the Central Armed Police Services.
On the prayer of
A. Bora.
A.
Bora.
Bora Learned Council for the petitioners, huh? This should be common only. Let this matter be listed after 4 weeks, 3 weeks,
3 weeks.
3 weeks, so as to enable her to file affidavit in reply.
Much obliged.
So and so. Madam, you get yourself recorded.
In item number 22, accessory the hearing and in 23 and 24 with exposure.
Ah.
And so accessory.
You just take the name, then council change for change are present, huh?
Here, my lord, government has filed the affidavit. We would like 2 weeks time to file the reply, my lord.
For the on the prayer of Mr.
AK Bora.
A.K. Barua, Learned Council for the petitioner, 2 weeks time is granted for filing affidavit in reply. Mr. So and so, sir, for response.
Obliged.
You also. So and so, at least for respondents are present. For respondents are present, huh?
I have already filed January 24 Lordship.
Okay.
Treatment Lordship, qualified on the ground of medical unfitness. I believe I have stated that medical, he was suffering from borderline cardiomegaly.
What is this?
That is a cardio problem.
What sort of cardiac problem?
Founding is an abnormal ECG.
Okay.
That is the review medical board have found, and we have also verified the documents that is he had annexed by civilian doctors, and page 44 Lordship. This is the report of consultant radiologist of Narayana Hospital Lordship, and their X-ray says PFU also there, borderline cardiomegaly.
No, which for the petitioner?
Petition.
He has a press medical report which found him to be normal.
The Lordship review medical board found, on the basis of that we have review medical board
after the filing of the writ petition, after the filing of the writ petition,
Yeah.
after the filing of the writ petition or before? No, he has undergone a test in a private hospital and his test is found to be normal.
Lordship, but the kind of review medical board is final. We have, once we have.
No, that
found-
is different issue. What I am asking is, this medical review board is after or before? Final, your review, final medical board report,
After detailed medical examination, when we found there is another chance of no. Thereafter review medical board and review medical board decision is final, Lordship. That is,
on the basis of that, petitioner has been discharged.
yes,
All right,
not discharged, he was not recruited.
recruited. Now, what I'm saying is, thereafter, see, according to him, he has undergone a medical test where the
That 1823, Lordship.
the condition of 1/8. Madam, are you getting me?
Lordship.
What I am saying, the basis of filing this writ petition is on the medical report
Subsequent to the review.
comes
medical board.
after the review petition. So the stand is the report of the medical review medical would be final. You don't rely on the other medical report.
Previously, whatever he had submitted, we verified that. Thereafter, we have given the detailed medical exam and again review.
That is why I'm asking, when he has submitted, have you had another review medical examination?
Medical.
That is why I'm asking, before or after? After.
Before, review medical is before.
Madam, he has claimed that his report is normal, placing certain documents. Whether he has been subjected to subsequent medical examination or not. I'm just asking, I'm not, deciding you are wrongly or rightly. I'm not on merit now. What I'm asking, what this court wants to know is, after the submission of his medical report, submission by the petitioner, whether he was subjected to subsequent medical examination or not. That is I wanted to know. Not appears for the petition on call. MS so-and-so learned counsel submits that she has already filed her affidavit. List of considering that the matter relates to claim for selection, claim for matter relates to selection to the post of constable GD in the Central Armed Police Forces. In the interest of justice, let this matter be posted after 4 weeks.
Seven.
May I please, Your Lordship?
Yes.
Matter is relating to the termination of the petitioner from the post of Anganwadi worker. Lordship, kindly turn to Annexure 1, page number 20, Lordship. On the basis of writ petition filed by the respondent number 5 along with some other person, there was an order passed by the Director Social Welfare, page number 20, Lordship.
Yes. Affidavit.
Lordship, I will file the affidavit, Lordship, but as per the order of the.
No, if you are filing, are you filing or not?
Not filed.
No, are you filing? You want to file affidavit or not?
Yes, Lordship, I will file, Lordship, but so far, Lordship, the appeal petition has already been
Pending, Lordship.
disposed of.
Dispose of.
Yes,
But the order
because-
has not been communicated, Lordship.
Huh?
But the order has not been
you will-
communicated till the filing of the
Show him, give him,
Lordship.
give him.
Yes, Lordship, we have filed the appeal on 21/2/2023. They have determined is on 30 March 2023, so that they have not communicated the order.
But it was disposed of. Lordship.
So you challenge that, we'll give you a liberty.
Lordship.
Mr. So-and-so, heard Mr. So-and-so learned counsel for the petition. Next para, Mr. J.K. Goswami, learned additional senior government advocate for the response by placing the, what is that?
Lordship,
Placing the instruction,
Lordship.
by referring to the instruction, submits that the appeal, where is that appeal?
Appeal is at page number, Lordship, 77,
Appeal filed by the petitioner.
annexure 14,
It is a statutory appeal.
Lordship.
Is it a statutory appeal? Is it a statutory appeal?
That appeal was filed as per the direction of this honorable court.
Okay. The appeal filed by the petitioner dated 21/02/2023 as directed by this court in which case?
Lordship,
Lordship, it is, Lordship, WPC 1779/2016, Lordship.
page 64, Lordship.
WPC,
Page 64. WBC number 1779. of
1779 of
16, Lordship.
2016, has been disposed of by the, who has disposed of this?
Lordship, it is that the director of Women and Child Development Assam, Lordship.
No, that is page 80,
Yes, Lordship,
30th
it is
March
already-
2023.
Yes, Lordship. It is already on record.
Ah,
We have challenged this order also, Lordship.
so then 30th March,
Annexure 15,
Yes, Lordship.
page 80.
yes,
30th March.
it's under challenge.
We have challenged this order also, Lordship.
And Mr. So-and-so, land council, Mr. J.K. Goswami, land so-and-so, is, fresh is granted further 3 weeks time to file affidavit.
Yes, sir.
May I please, Your Lordship?
Yes.
Your matter relates to selection and appointment of Gao Pradhan Lordship in village Bologora, Niskharupetia under district Dorong, Assam. Your Lordship, the petitioner participated in the interview. from-
Yes.
My lord, that
And appeal is pending, Lordship,
appeal is filed before the, my lord, that
divisional commissioner,
divisional commissioner, Lord, Manat,
not
or page 35, Lord, not Assam division.
Huh.
Now, my lord, this, my lord, that divisional commissioner, my lord, that post has been abolished. Now, my lord, this appeal is live before the, my lord, director of plan record. In pursuant to this order also.
Lordship, as per my instruction, this appeal is already transferred to the
Obviously, you cannot,
Yes. After abolition of this post of commissioner.
automatically it will go to the concerned person who has been entrusted.
That over telephonic instruction, my lord, that appeal was not received by the director of land record. That's why, my lord,
It was already numbered, Lordship, so it needs to be transferred to the competent authority, whoever may be at this time, Lordship.
So what's the problem filing a fresh
This
petition?
appeal is not considered, Lordship, till that. It
No,
was-
no, what they are saying is you have filed the affidavit, the appeal before the commission, district commission.
That time, Lordship,
Ah,
yes.
that,
you are not informed.
Lordship.
There is no fault on your part.
Yes, Lordship.
By now, this has been given to the an appeal against the order. The district commissioner, the post of this has been abolished.
Divisional commission.
Division has been abolished now. And it's been entrusted with the director.
Director of Land Development. Whatever the appeal has been, my lord, submitted along with this, my lord, lead petition, my lord, that have to be submitted before the, my lord, Director of Land Record.
No, but by change that the time he has filed, you cannot harass them. It's a kind
Yes,
of
Lord,
harassment only.
You cannot harass, lord.
You
My
have
lord,
changed the
that,
law.
my lord, appeal was not received up. Because of that, my lord, we cannot be, my lord, proceed further. Lord.
So what do we
It-
do, sir?
Lordship, it was
They'll come tomorrow, they said they'll know, you will not, they say, we cannot do it now.
submitted before the divisional commissioner, and as per my instruction, Lordship,
Huh.
it was transferred to the competent authority, Lordship, and
Obviously, it should have been.
Lordship. And all,
You just cannot, you just
is
cannot,
already numbered,
you just
Lordship.
can't throw away the documents.
Yes, Lordship.
It was, at that point of time, it was appropriately
It was-
filed.
Initially, when it was sent to the General Administrative Department.
Huh,
But
yes.
because when long back, they have taken over, the ERR has taken over long back, the lordship sees the case which was filed. This long back, 23 itself, the ERR has taken over. That particular.
So you extended that there is no appeal
No one,
pending.
Lord.
It is already numbered, Lordship, case number 41/2023. It is,
See, these
it
are
is-
small, I mean, the
it is an official
unnecessary
record
things.
now, Lordship.
Ultimately, we'll have to go. So what I'm suggesting is that why don't you file, because the authority has changed and they are saying that they have not received it. You are for director.
I'm for the, my lord, Director of Land.
Yes, they said they have not received it. And after 2 years or so, they said since there was not appeal, we could not consider. So who will be the affected? You,
Lordship, appeal is submitted.
they'll be happy.
It is already numbered, Lordship, and after Lordship, it is an official record, whether they have received it or not, it is an
No, in fact,
official
Mr.
communication, Lordship.
This thing, sir, you cannot do like this. The moment the authority is shifted, the file has to follow.
That is true, Lord. So whether, my lord,
Otherwise, it will be a-
initially states, my lord,
it
was
would
sent
be
to
a
the jail.
harassment.
After, my lord, the Director of Land. Record-
Sir, otherwise it would be a harassment of the citizen.
Lord-
What is to be done? I want to file a press petition.
Lordship, it is already filed.
Appeal or you want to
23. We are waiting
you
for
want to-
disposal of the appeal, Lordship. Now press appeal. And there is a time period, Lordship, limitation
Time
period.
You know, my lord, lordship can, my lord, that appeal which was, my lord, and close, my lord, this the petition.
Madam, I think it's better you file because it's
Then
better you
file,
should
but
file.
yes, my lord, we will take immediately.
Because tomorrow also, even if we grant them a time, they'll come and say, they'll file an affidavit saying that we have not received because of these developments,
Lordship.
subsequent development. And unless we accept to pass and make some remarks, ultimately substantial relief would not be able to, we would not be able to consider your
Lordship,
relief in
in the matter,
Substance.
petition may keep pending, Lordship. In the meantime, they may consider the appeal. We will file a fresh appeal.
Okay.
Otherwise, they will keep
Not
it
Mr.
pending.
MS Swanshaw, Learned Constable. Mr. J. Hendrik, Learned State Council
For the Revenue Department.
for Revenue Department, Standing Council,
Lordship.
Standing Council, Revenue Department submits that in view of the this way, in view of the and Mr. A. Pukar, Learned Standing Council for, huh? GAD.
And some other.
Who is responding five?
Private.
Who is three?
Yes, four.
Who is 3 and 4?
The district commissioner and my
Ah.
lord, selection.
have submitted that in view of the notification dated which 01/02/2024. An appeal against the order of the order of appointment, suspension and dismissal of Gao Pradhan by the district commissioner or by the principal secretary of the autonomous council area shall lie to the director of land records and surveys Assam. Where is Mr. The petitioner has filed appears to have filed his appeal
That's right.
before the divisional commissioner,
That's
then division commissioner.
Not Assam division.
Huh?
Page 35 Lordship.
Division commissioner. under
Commission
the
is not Assam division, just
Not something.
and 30.
35.
uh, Not Assam division at Tezpur. Which has been now abolished. Mr. No, is now abolished, comma. The authorities, the concerned authorities, particularly Director Land and Surveys, has not received the said appeal. Mr. The so Land Council submitted that the petition, the appeal of the petitioner having been already numbered should have been placed before the appropriate authority on being even if the earlier authority is abolished by placing before the Director of Land Records and Surveys. However, she submits that she may be granted, she may be allowed to file afresh before the Director Land Records and Survey during pendency of the petition. Next parent. We are not being objected to the Land Council for the respondents.
Time limit.
Let this
is-
matter be listed after 3 weeks,
Lordship.
comma, in the meantime, the petitioner may file his appeal before the director so and so, huh?
Time period may be fixed for Lordship disposal of the appeal.
No, we're not saying. First you file, then
Yes, Lordship. And also.
the respondents are also directed to file their respective affidavits. You also file the affidavit. We'll consider, well, in the meantime only, we're just,
And also Lordship, limitation period shall not be attract
in that case, we'll dispose of the matter. We'll close the matter. We'll close the matter.
It is better.
No, no,
to-
no.
Then why we should, virtually will be granting the relief only. We'll close the matter, granting them the time frame.
No, Lordship, it may be.
We'll provide time frame.
Pending Lordship.
Then?
Lordship.
Okay. We'll continue at 2. On the prayer of MSO and so, Land Council to the petitioner. Further 3 weeks time is granted to file affidavit in reply. MS so and so, learned counsel, learned CGC is present.
May it please your lordship. My lord, an affidavit has been filed by the department. Now, in terms of this affidavit, perhaps this matter can be disposed of with a direction for payment within a time frame. The lordship kindly takes up the affidavit in opposition filed by the respondent number 1, 3, and 4, and may come to page number 58, the last paragraph. Page number 58, the last paragraph, my lord, of the affidavit. May I read? The deponent begs to submit that fresh proposal shall be submitted for sanction of the arrear amount and other pension benefits at the earliest, so that the same may be disbursed to the petitioners within this financial year. Now, this was the affidavit that was torn in 2024. In fact, exactly a year ago, 17/5/2024. Now, till now, my lord, no payment has been made. The payments that which we are asking for are the area salary of the deceased brother of the petitioners who died intestate. He did not have any family. So the brothers have come before this honorable court. And the other payment being the payment of DCRG, death cum retirement gratuity. That amount also was not paid. Now, here they have in their affidavit said that a fresh proposal would be sent. That was exactly a year back. Now, my lord obviously, my lord, be pleased to pass a direction since the liability is admitted. Let them within a time frame make the payment, because they say that they have already sent the proposal and it's about a year now. In fact, more than a year.
We're on behalf of Standing Council of Animal Welfare and Veterinary Department. Standing Council is suffering from high fever, not that we can come to the summer.
And
Who?
And for cooking. Activity for lordship finally adjourned for the day.
otherwise, their admission is here, but since she has, I leave it up to your lordship.
No, if there's no dispute, it's a matter of time only. If if there's no dispute and if it's a matter of time only, at least you could have obtained the instruction from the standing council. Anyway,
My lord gives me a fixed date, my lord.
next week, we'll take it up next week. All right. Will she be all right by next week? If not, you take an instruction in view of the, you have seen,
Yes, the affidavit.
you have seen the affidavit.
Yes, read this last paragraph. You were already, it is admitted. This is the last paragraph. Let it be on a fixed date next week.
Will not say after a week, next week we'll say.
Next week, my lord.
Heard Mr. D. Chakraborty, learned counsel for the petitioners. MS Soenso, learned counsel. Appearing on behalf of MS MM Potoki, learned standing counsel, veterinary department, submits that. Learned counsel is, the standing counsel is suffering from high fever, therefore she could not appear before this court today. Message stress for listing of the matter after a week. Having considered that the listing counsel is not keeping well, let this matter be listed after a week.
My lord, I humbly pray for a day. It's a pensionary matter.
It's all right. Next week it will be listed.
My lord.
May I be lordship? Yes. Lordship, the petitioner was dismissed from service, my lord. On the ground that he was involved some illegal activity during the detailed medical examination in the recruitment rally conducted by the Assam Rifles, my lord. And after the dismissal order, we have filed the appeal. And the statutory appeal is still pending, my lord. So today, I am praying that this appeal may be directed to may be disposed of, my lord. As per the remedy, my
As per appeal is pending, lordship, then let it be disposed of.
Why direction is required?
as per
Then-
the, as per the,
Then statutory appeal,
Yes, Kalyan.
departmental appeal.
Yes.
So why we are not disposing now? You take instruction next week. When was the appeal filed?
it was filed on
June 20.
10 May 2022, my lord.
Yes.
And thereafter,
2
affidavit,
years.
affidavit in opposition has been filed, my lord.
What is there? You consider and do you find anything rejected? At least let them
Whatever may be,
proceed.
my lord. As
Let
per
them-
the Some Rifle Act and Rule, my lord, the remedy for re-examining the fact is there.
Or should I dispose? What direction should we
It
require?
may be,
Huh?
Can dispose it. Directing to finalize the appeal within a period of 4.
Okay. Heard Mr. So and so, learn counsel for the petitioner. And Mr. SS, learn CGC for all the respondents.
All
The response. Next one, by filing this writ petition, the petitioner has put to challenge the order of dismissal dated 04/06/2020, where it is
page number 48, my lord, Annex 3.
58. Passed by the brigadier. Brigadier and Deputy Inspector of General, same.
My lord,
Brigadier of Deputy Inspector of General, Assam Rifles. Hereby in excessive power under Assam Rifles Rules, Assam Rifles Act 2000. Read with rules, read with the Assam Rifles Rules 2010 has dismissed the petitioner from service. After inquiry or any other departmental proceedings?
After court of.
after court of
Sorry,
inquiry.
after court of inquiry. Mr. So-and-so learned counsel to the petitioner. At this stage, petitioner submits that although the petitioner has raises many grounds challenging the dismissal of the impugned dismissal of the dated so-and-so, so-and-so. The appeal, a departmental appeal, the statutory appeal, where is the appeal?
Page number 50, my lord, Annexure 4.
50. Filed by the petitioner on 10/05/2022 before the appellate authority has not been disposed of as on date. Therefore, he prays for a direction to dispose of the said appeal dated 10/05/2022. Mr. Next, Mr. SS. Then CGC clearly submits that the authorities are obligated to consider and dispose of the appeal. This is an appeal or what? application for reinstatement service where is a statutory appeal under which rule?
Under section 139 of Assam Rifle Act 2006, my lord.
Where it is? Obligated to consider and dispose of the appeal filed by the petitioner. And the same is a statutory appeal under the rules. Next page. Where's the rule? Do you have the rule?
My lord, section 139, my lord.
Rule. This is rule or section?
Section, my lord, section 139, Assam Rifle Act 2006, my lord.
139.
My lord.
139.
2, my lord.
Remedy against order, finding or sentence of assembly. Okay, huh?
139, 2, my lord.
Next page. Before his submission, huh? Before his submission. Come on. Please, next page, huh? Before their submission. The petitioner joined the Assam Rifles as rifleman of the GD on 03/04/2004. And completed his military basic training and trained in the Assam Rifle Training Center, Dimapur, Nagaland. And was posted to 33rd Assam Rifles of C/O99 APL. And thereafter to the various places of posting in the Northeast region. What is the allegation?
Allegation, my lord, the petitioner was involved in some illegal activity during the detailed medical examination
Of
in
what?
the recruitment rally, my lord.
Okay. Next para. Well, the petitioner was cited as Swakos Nofu on 01/02/2020. Alleging and Weber, it was informed that during the staff bottom inquiry convened by the convent at laboratory maintenance group assembly, it was found that the petitioner was involved in a case of impersonation, as he was not informed as superior officer about the impersonation in violation of the Official Secret Act. And also attempted to misuse his official capacity. In a calling directed to submit his reply within 30 days. The petition submitted his reply. However, the authorities has proceeded with the inquiry. After the completion of the inquiry, conducted by the staff court of inquiry about the impugn order of dismissal from service dated so and so has been issued by the Assam Rifle, the brigadier so and so, that same dismissing the petitioner from his service. Next page. Then you write that submission. No. Having considered the submissions of learned counsel for the parties. Last, after their submission. And as agreed to the learned counsel to the parties. And realize considering the provisions of section 139 of the Assam Rifles Act. Where is the Assam Rifles Act 2066? Among the considered budget. The respondent authorities are deserved to be directed to consider and dispose of the appeal dated so and so, filed by the petitioner. Accordingly, this writ petition is disposed of with a direction to the respondent authorities to dispose of the appeal of the petition that is so and so, within a period of 2 months. 2 months or 4 weeks, within a period of 4 weeks. From today. From today. What certified copy? From the date of receipt of the certified copy of this order. Writ petition is then disposed.
Deep reduction.
You'll just mention, needless to mention that if the petitioner is agreed with the outcome of the appeal that may be passed by the responding authority, is at liberty to approach this court again.
My lord, deep lordship.
Avail the remedy available as may be permissible under the law.
My lord.
Not this court, remedy, any remedy.
My
remedy.
lord. Much of lordship.
32.
But the matter relates to pensionary benefit.
Yes, sir.
And state government has filed their affidavit.
Saying
The
what?
accountant general has not filed their affidavit.
So,
If they.
who is accountant general?
State government affidavit is in my favor to some extent.
Okay. So,
But at the instance of the accountant general office, his last scale of pay was reduced by 1 increment. And
One
thereafter
increment.
the pension was fixed. And
so is for the AG? Okay. Or Mr.
if they prefer to affidavit, file an affidavit and all that.
So and so, huh? For the petition. And you are for estate? Mr. J.K. Goswami, additional senior government advocates.
No, 2 and
Oh.
5, no, 5, no, director of pension. State, no?
For a state submits that he has filed this affidavit. He has already filed the affidavit on behalf of the state. Next, Farah. Mr. So-and-so, learned council, what? Standing council or learned council? Standing council, accountant general, respondent number 5, 6.
No, 4.
Respondent
3,
number
4.
3, 4.
Here,
Press for and is granted for the 3 weeks time to file
only 3, 4, no?
affidavit.
3, 4.
List after 3 weeks. 3 and 4.
Copy লাগবে দিয়ে দেখ একটা কপি একটা কপি যাবে দুটো কপি বা
Maybe before. My lord, matter
Just
is
wait. Yes.
my lord, matter is relating to pecuniary benefits, my lord.
Yes.
Error amount. I think respondent authorities, I think, are expected, my lord, to finalize by this time, my lord.
Lordship, in terms of Lordship last direction,
Hmm,
the matter is under consideration on urgent basis, Lordship.
hmm.
And as the petitioner is only the legal representative of the, the deceased employee.
Hmm.
So she was asked to furnish a indemnity bond, Lordship, which she furnished only day before yesterday.
Hmm.
So I am expecting Lordship, as I have been told, Lordship, within next 15 days, it is going to be finalized. So Lordship may take up this matter after 2 weeks.
That may be fixed, my lord, in the meantime.
They are going to finalize, we'll close the matter.
Yes, otherwise. so
My,
far as-
my lord, let him disperse and submit a report, my lord. My lord, if I may suggest, my lord, let them disperse in the meantime and submit, my lord, the report.
We cannot be like.
Because ultimately,
it's-
as submitted, my learned friend, my lord, it's almost, my lord, under process.
Been
Because it's, my lord,
engaged as a.
Monitor.
lordship may see if it's a matter relating to 1996 year, my lord,
Scarecrow.
1996, my lord.
Yes, sir, this.
So that's why they say they'll finalize it.
Yes.
15 days. We'll record his submission and we'll close the matter. What's there?
My lord,
We cannot be a scarecrow.
my
You know
lord,
that?
ultimately, if the matter is closed, my lord, tomorrow if something, my lord, again I have to
We'll
come, my lord.
provide you a liberty. We'll provide you a liberty. They are not disputing. They are saying that they're going to
As per
finalize
their
soon.
submission, lordship may, otherwise may, if lordship dispose of the matter, my lord, with a direction, as per their instruction, my lord, whatever is submitted. by
No,
my
they
learned
said
friend, my lord.
record their submission. In view of that, we'll close this writ petition. We'll give you a liberty to approach if you are agreed.
My lord, dispose of the matter, why
In
close, my
future.
lord?
Huh?
Why close, my lord? Dispose of the matter, my lord, writ petition. In terms of the submission, let my learned friend, my lord.
Let this matter come after 2 weeks, Lordship. In the meantime, I will pay the complaint. Let this matter.
Okay. Heard Mr. N.K. Muri,
Yes, my lord.
learned counsel for the petitioner. Next para, this court on 11/04/2025 granted Mr. Nayak. Granted the respondents on the submission of the Learned Standing Council for GMC, Mr. P. Nayak, to finalize the claim for family pension of the petitioner by today. Mr. Next, Mr. Nayak, Learned Standing Council. Submits GMC, submits, not GMC, Learned Standing Council. Submits that since certain documents were sought from the petitioner for finalization, of the claim of the petition, which he or she, which she has submitted only day before yesterday, I 26/05/2025, comma. The GMC would require, the authorities would require at least 15 days to finalize the claim as sought by as submitted before this court in the earlier dates, huh? Therefore, praise that matter may be listed after 2 weeks. Having considered that the petitioner has submitted required documents which the authorities have sought for on only 2 days back, the prayer of the learned standing counsel, Mr. P. Naik, is allowed. Mr. Accordingly, list this matter after 2 weeks.
That may be accommodated, my lord. That may be
It
accommodated.
will be listed.
My lord, here, my lord. This matter is regarding my lord scale pay, area scale pay, my lord. I don't know whether my learned friend is having instruction, my lord.
Next is your lordship. Your lordship, in this matter, your lordship, as a belief that the petitioner is working as a child development protection officer. Your lordship, it doesn't fall under the purview of the Social Justice and Empowerment Department. Your lordship. I'm on behalf of the Esplanade from one and your lordship. Yes. You are not a concerned department. No, your lordship. Yes. Yes. You are for whom? Exponent number 1 and 2, your lordship. Social
Yes.
Justice and Empowerment. Director of Social Justice and Empowerment.
Yes, sir.
Then? Your lordship, the petitioner is currently working as a child development project officer. It doesn't fall under the purview of the Director of Social Justice and Empowerment, your lordship. Which department is it falls? Your lordship, as far as I'm concerned, it falls under the Department of Social Welfare, your lordship. Lordship, if you look at Perus, page 22 of the petition, your lordship, you will find a previous case filed by the petitioner, your lordship. In that case, they make the correct department a party in the petition, your lordship. So, who is the appropriate department?
No, earlier, my lord, there is some discrepancy, my lord. Earlier, it was, my lord, fall under somebody, my lord. That, my lord, now it's come, what I've been instructed, my lord. Now it's come under Director of Social and Justice Empowerment. That department is already amalgamated, my lord. Designated. Nomenclature changed, my lord. Nomenclature has been changed, my lord.
Who is
But-
correct? He is correct or are you, you are correct?
Now, my lord, lordship, if we see in my lord, Annexure 1, my lord, that is the
No, we don't have to see all this.
present status, my lord. I am working under District Social Welfare
What is
Office.
the correct position? Which department you are serving? Against whom, which department you are claiming your relief?
I am working admittedly under respondent number 4, my lord.
It's the question of immediate or not immediate. You, in that case, you make both the departments. Against which department are you claiming your relief?
That previous which I have been working, my lord, that no longer exists, my lord. It's already, that designation has been renamed, my lord.
It has been redesignated.
Yes.
So, which is the new
This
name?
is the new structure, my lord.
What is the new structure, sir?
My lord,
What is the name of the new department?
new department, my lord, I have completed here, my lord.
Which department, sir?
Director of Social Welfare, my lord. Social Justice and Empowerment.
Your lordship, as far as the instructions I have received, your lordship. You file an affidavit on that. Heard Mr. So-and-so, learned counsel for the petition. Mr. So-and-so, learned counsel, appearing on behalf of respondent number, huh? You are C. Burua. C. Burua, go ahead.
Appearing on behalf of Mr. RM Das.
Appearing on behalf of RM Das, Learned Standing Council for which department?
Social Justice and Empowerment.
Social Justice and Empowerment. Come on, Government of Assam submits that the department which he is representing, the petitioner is not working under the Department of Social Justice and Empowerment. Where he is working in that case?
I have yet to receive the instruction. Matter.
Arre, sir, what is this? You said you have the instruction. Mr. Swed, huh? Appearing on behalf of the press board, it is granted further 3 weeks time to file affidavit. Replacement. If you don't have the instruction, clear cut instruction, don't make a submission. Unnecessary.
Applies matter.
Yes, I complied.
Here one of yours, what you can see the respondent name. A content application was for the incumbent. It was pointed on the last basis.
Yes,
Then he was,
you have to make by name. By name, sir.
no, my name.
You have to implement them or edit them as by name. It's a contempt proceeding.
No, director, not only one director, the post is director.
Whoever is there, who has to comply with the court's order?
No, no,
Who has to comply with the court's order?
No, director's name has not been given, but the post is director, who is the authority.
Therefore, I'm saying,
It is like coming and going, so many years. The matter is pending.
sir, you have to make them
Particular
person,
appointing
yes,
authority.
by name.
Yes, my lord.
Whoever is in the, office presently.
The thing
Sir, this is elementary. Why we have to say all this thing? I think this has been recorded earlier also.
the director, the name has not been given, but because of the director is coming and going, and the present director means
Momota Hussain.
Hussain.
Momota Hussain.
It's a present.
Present.
Sir, these are elementary.
Idile.
On the prayer of Mr.
Malakar, R.K. Malakar.
R.K. Malakar, learned counsel for the petitioner. And having considered that in this contempt petition, the incumbent has not been added a party respondent, but only the post has been added. Further 3 weeks time is granted to take appropriate, for taking appropriate steps. List after 3 weeks. You implement them by name. You implement them by name. Yes. Of course.
May I please? Lord,
by order dated 30/4/2025 in IA number 1315/2025. The respondent number 9, 10 and 11 have been made party respondents, but notice has not been issued. So, my lord, a notice may be issued to the respondent number 9, 10 and 11.
Heard Mr. So-and-so, learned counsel for the parties. You filed in the application,
Yes, amendment has been allowed.
Implementation is allowed.
allowed,
Yes,
already allowed,
Yes.
allowed.
But notice has not been issued.
okay. And also heard Mr.
Well, I am appearing for respondent number 2.
B. Kaushik, learned counsel, who is for one? Chief Secretary, Jishnu Borwa.
Chief Secretary, wrong.
Yeah. For the list container number 2. And
I give 6.
Mr. S. Bora. Learned counsel for the respondent number 6. Please the issue notice to the respondents number
9, 10 and 11.
9, 10 and 11, who has been newly implicated in this contempt proceedings returnable by 4 weeks. Learned counsel for the petitioner.
Madam,
take his
the steps
for
within 3 days, ma'am.
So and so, within 3 days, so and so. So and so. Huh?
Deep Lord bless.
Lordship, I may be allowed to take fresh steps upon respondent number 3, 4 and 5 as per the laws of order, Lordship.
For the 3 weeks time is granted to 7 days time is granted to the learned counsel for the petitioners to take the first steps for service of notice upon respondent number 3, 4 and 5.
Yes, Lordship.
This up to 4 weeks.
All right, Lordship.
May I please your
Yes.
lordship? Lordship, I am appearing on behalf of T. Chakrabarti. Lordship, the Lawazima order dated 10/4/2025. The service notice upon the respondent number 5 has been completed. So Lordship may be fixed on the next date for admission.
For respondent number 5,
Yes,
only respondent number 5.
yes.
Okay. Heard so and so learned counsel for the petitioner. Order dated. No, the Lawazima court order dated 10/04/2025 indicates that reflects that the service in respect of the respondent number 5 has respondent number 5 is completed. This thing. Will be of the service complete list for admission hearing after 4 weeks.
Much obliged.
Yes,
But here the petitioner had read allegation against the respondents that his APA, that ACR and his medical condition was being kept below the required readings by especially the respondent number 4 and 5 to mar his career service. Now, while issuing notice, notice was not issued to respondent number 4 and 5. The other respondents have filed their affidavit from which it is evident that the respondent number 4 at least had deliberately kept his gradings below benchmark for the petitioner. At this stage, my lord, perhaps a notice to respondent number 4 and 5, so that the particular paragraphs where I have alleged bias against them needs to
so
be answered
notice
by
has
them.
been not been issued.
To 4 and 5 notices to go, my lord.
Why? It was not
Because, my
issued?
lord, I had made specific allegation in the writ petition.
No, why this has not been issued
My
earlier?
lord, at that point of time, the court wanted to see whether on the affidavit of the respondents, any act could be attributed to 4 and 5 to keep my APRs below the benchmark grading. Therefore, my lord, while issuing notice on 2/3/2022, if I'm not wrong, my lord, 4 and 5 were not issued notice. Now the affidavits have come. In fact, this Special Director General has remarked that respondent numbers 4's remarks were not called for. So therefore, now, my lord, he has to answer the question of bias that he held against me to hold back my promotions at that particular point of time. And respondent number 5, who was a doctor, despite, my lord, there being specific reports that I'm fit for duty, he kept me unfit for training.
It's okay. 4 and 5.
4 and 5, my lord, if notices
4
to
and
show.
5.
But that has to go through respondent number 2, my lord.
Huh?
The notices have to be served through respondent number 2 because now they've changed their positions. At that point of time, he was a commandant. 4. Now he is a DIG. So that,
Heard Mr. Majumdar, learned counsel for the petitioner. And Mr.
B Sharma, my lord.
B. Sharma. For learned CJC.
My lord, see,
by name is sir.
Learned CJC. For respondents. Learned CJC. Issue notice to the respondent number 4 and 5.
4 and 5. my lord.
Returnable by 3 weeks, 4 weeks. Next week. Steps be taken within 3 days.
my lord, here, 4 and 5 are the, my lord, by name was their name.
That's why
So, registered is steps.
through the respondent number
2.
I.
The page
Director
3, my lord.
General Sasitra Simabal, SSB, huh? PHQ, Netherlands. List after 4 weeks.
I'm deeply obliged.
Yeah, when we say 3 weeks or 4 weeks, we'll make it 4 weeks.
My lord.
It's a deadline.
I'm obliged.
Non appeals for the petition on form. Despite granting of 3 weeks time to file affidavit in reply. No affidavit appears to have been filed. List matter after 6 weeks.
A occasion, that's it. Say, last occasion, direction was given by this court to bring some instruction on some point, but the respondent did not find.
Yes, Mr. Pegu. For respondent number 3, who is Mr. Pegu? Yes, who is Mr. Pegu? G. Pegu. For respondent number? Who is respondent number 3? Sir, who is respondent number 3?
Chairman, District Scrutiny Committee.
Deputy Commissioner. Huh?
Chairman, Deputy ones. Chairman.
You're supposed to obtain instruction. Huh? See, the order was passed on 08 to this January 8 January, and then it was granted further on 30/01. Then or Mr. So-and-so, learned counsel for the petitioner. This court has granted the learned counsel for the learned counsel, state council, learned state council, an opportunity to file affidavit. However, none appears for the petitioner on behalf of the respondent number 3. Today. This court expresses its displeasure on the part of with the London District Council for not for not filing the affidavit as although not filing the affidavit despite granting of opportunity twice. However, in the interest of justice, let this matter be listed after 2 weeks. On the next listed. On or before the next 8 weeks, the London District Council shall file the affidavit as directed by the score by 18/01/2025. 2 weeks. You inform G Pego or G Devi whoever is there.
Lordship, in this case, probably he will file the affidavit.
Lordship, 2 weeks time may be granted, Lordship. I will file my affidavit, Lordship.
It's a disciplinary proceeding, major punishment is taken.
SP Chaudhary.
Yes, Lordship.
Learned counsel for the petition. Mr.
D. Upamanya,
Dupania, London Standing Council.
Health and Family.
Press for granted for the 3 weeks time to file affidavit.
Lordship, kindly fix a date because the person is going to retire very soon. At any date after 3 weeks, Lordship.
Any date after 3 weeks.
Difficulty is that, Lordship, then again I have to make a mention for listing and then to approve the registration.
Mention what's there.
Highly advised. With regards to item 41, my lord, I'll get an instruction.
Twice you have been granted.
This issue when I implead it, sir. I was engaged in another court, my lord, so just now I got a call.
So you have the instruction, have you filed the?
No.
Then?
No. So I pray for further 2 weeks time.
It has been granted, but we.
I'm sorry, my lord.
Get some remarks
My lord.
against you.
My lord.
We have recorded some remarks against you,
My lord.
expressing the displeasure. What is to be done?
That will be responsibility.
You delete that.
That might be my lord. That's fine.
We'll just correct it. That express the truth you know today, but say that despite so and so, so and so. So and so, I failed to find the affidavit. Today, Mr. G. Pekar, so and so, so and so. Press. So last opportunity.
My lord.
Granting a last opportunity. Yes.
Make it, your lordship. This matter inadvertently, we have not filed the amended cost cycle, your lordship. We'll file it within 2 days and
On the prayer of Mr. M.H. Laskar, Land Council for the petition. List this matter after 3 weeks.
in the meantime, I'll do. Oblige, lordship.
May I please your lordship? Lordship, service has been completed on responding number 4 as per latest.
Service complete.
Yes, your lordship. Completely. Principal now. Lordship, can kindly fix this. for-
Response number 4.
Yes, your lordship.
And Mr. So-and-so, then so. Service. Upon response number 4 is complete. List for admission after
Highly obliged.
4 weeks.
25.
May I please, your lordship?
Yes.
Lordship, I beg to, for one week time for steps, lordship.
What
Alright.
steps? You have not taken
After-
steps.
Yes, lordship. Upon respondent number 4 to 15.
Next para. Miss M.S. So-and-so, Land Council. Press for and is granted further 3 days time to take precise steps upon the response number 4 to 15 as a last opportunity. Mr. So-and-so,
Elementary education. GPay.
Land
On this.
so-and-so, is present. List after 4 weeks.
Deep level.
Obliged.